I'm so happy to be with you all this morning. I wish we were sitting somewhere together, maybe in a coffee house. I also wish that I was trilingual instead of monolingual so that we could all speak in the language that we are accustomed to and yet understand one another well. But even with those limitations, I'm so happy to hear what you have to say. It is inspiring and encouraging to me, and I need inspiration. I am a Californian. I've always lived in California, in the American West, by the ocean. I've been an attorney in California for an incredibly long time, 47 years. I worked for 22 years before I retired from government for the city attorney of Santa Monica, where I was the city's city attorney. So I headed the city's law office. I am the principal author of Santa Monica's Nature's Rights Resolution and its ordinance. After I retired from, because of the work that I did, my areas of expertise are US constitutional law and governmental law, public law at all levels in the US. But I've only practiced law in California. That's where all my experience has been. After retiring from my job as city attorney, I started working for the Earth Law Center, which is based here in the US in Colorado. And I also do a lot of volunteer work whenever the UN's Harmony with Nature program needs help. My current title is Senior Counsel at the Earth Law Center, but the title doesn't matter very much. I just work for the Earth Law Center. I want to talk about the current state of the rights of nature movement in the US and how our laws and our political, governmental, and economic systems have created obstacles to the movement's success. But I also want to talk about the fact that the rights of nature movement is growing rapidly in the US despite those difficulties. Significant setbacks have occurred in our courts and in our state legislatures. It won't surprise you that powerful corporate interests have used their influence and the resources to fuel opposition to rights of nature, which they believe is, the movement is adverse to their financial interests and success. No surprise there either. One reason that the rights of nature movement is successful and very popular locally with the people is because the evidence of the environmental catastrophe is everywhere apparent in this country. It's so visible that people have here, especially in California, become unable to ignore the evidence that we must change our laws and we must change the way we live. It is increasingly understood here that we must do that for our children and their children if they are to have a decent future. Here in California, I want to talk a little about California because I believe that people attach to nature locally. It's not, for most of us, for most people, I think nature's health is not a theoretical or even a scientific issue. It's what they see and feel around them. Our climate is mostly hot in California now. We have a short rainy season in the few winter months. Summers and the dry season are long. Our combination of steep terrain and our climate make wildfires, endemic here in California. Our fresh water comes from the snowmelt off of the high Western mountains, the Sierras and the Rockies. The snowmelt is vital. It supplies our drinking water, our agricultural irrigation, and our hydroelectric power. But in the last 20 years, our climate has gotten much, much hotter, and our land is suffering a horrific drought. Snowfalls are a small fraction of normal, and the water supply has dwindled to the lowest on record. Scientists have concluded from the tree rings in the state that this is the worst drought in the Western US in 1,200 years. 1,200, that's the entirety of recorded history in Western America. In California's huge central agricultural valley, private wells have dried up. Deeper and deeper wells are being drilled, but that short-term fix to the agricultural industry's problems here, that short-term fix of drilling deeper and deeper wells, has caused the floor of our Central Valley to sink because the aquifers are being exhausted. In some places, the sinking occurs as rapidly as 1 foot per year, which is almost unbelievable to me. Our wildfires have intensified, scorching hundreds of thousands of acres in the last 5 years. Whole communities have been destroyed by wildfires. As I said, we have always had fires, but it is a new development that we have fires so hot and so fast moving that they can destroy an entire community in a matter of hours. The saddest example is a mountain town in California that ironically is named Paradise. Paradise, 3 years ago, I think it was, Paradise, the entire community burned up in 3 hours. 80 people died, and most of them died burning to death in their cars trying to escape. But the fire was moving so fast, they couldn't. The firefighters, professional firefighters, career firefighters who were interviewed after that fire and were so upset by their experience that they could barely talk about it, said that there is no way to suppress a fire that is that hot and that fast. The only option is to try to get out of its way and let it burn itself out. And that's what happened in Paradise. The fire continued to burn for days, and finally it rained, and that put the fire out. A perfect example of how little control humans actually have over nature. On top of this, on top of the changes in the fires and the water supply, our most beloved iconic species are dying. The giant sequoia trees in Yosemite and Sequoia National Parks have been damaged by fire. Firefighters, desperate to protect them, even have attempted to wrap the lower portion of the trunks in aluminum foil to try to keep these trees alive. In the Mojave Desert, the iconic species is the Joshua trees. Swaths of them are dying. Our formerly huge salmon populations are decimated by climate disruption and other and human activities. And the decimation of that population endangers other marine populations, the most famous being in the Northwest being the resident orca killer whales. The city I live in is named Thousand Oaks because for all human time, the hills here have been dotted with enormous oak trees. Those oak trees were the principal food source of the first peoples of this area, who were the Chumash people. The Chumash people, as they report on their website, are actually doing fairly well despite near decimation by the Spanish conquest of California. But the oak trees upon which they depended are now dying. It's horrible. It's horrible to watch. And this catastrophes, and I'm talking about, are apparent even in our large urban centers, Los Angeles, San Diego, and the San Francisco Bay Area, where skies have turned orange from distant wildfire smoke, and where schools have been closed because the outdoor air is too unsafe for children to breathe. So everyone in California who has their eyes open, or is smelling the air, or is feeling the heat, knows we have an emergency. And I think that's part of the reason that they are turning to rights of nature in increasing numbers, despite the difficulties it's encountered in the courts and the difficulties with state legislators. In the last 2 weeks, we've been whipsawed from fire to flood. An atmospheric river has brought record rainfalls. Hillsides that were stripped of vegetation by the fires are slipping. We have landslides, and we have major flooding, last Saturday, 25 million residents of California were placed under a flood watch, which means the government has determined that where they live may flood and they may have to evacuate. So Californians, like those in many communities in the US, have turned to rights of nature as a possible remedy. We see all around us the evidence that our current legal protections are inadequate, as was mentioned earlier in this meeting. But some of the communities that adopted rights of nature laws were immediately encountered very significant legal problems. Corporations and states filed lawsuits, and those lawsuits repeatedly overturned invalidated rights of nature laws in the US. Most of the court decisions overturning, invalidating rights of nature laws in the US, most of those decisions were based on the US Constitution or on federal or state statutes. As you all probably know, the US has a federal system of government, so our federal laws are outrank and are higher than our state laws, which are higher than our municipal laws. Local and state laws must comport, be consistent with federal law, or they will be invalidated by the courts. I want to tell you about the most significant legal battle that's occurred in the US, at least the most significant in terms of the rights of nature movement. It took place in the city of Toledo, Ohio. Toledo is located on the shores of Lake Erie, which is one of the 5 huge lakes on the Canadian border in the center of our country. This is a region of the country that's dominated by, I'm so sorry, my husband will answer that, I hope. That region of the country is dominated by industrial and farming industries. Lake Erie provides the drinking water for 11 million people, including all of Toledo's residents. For decades, the lake's waters have been polluted by agricultural and industrial runoff, and that runoff causes, among other problems, it causes huge blooms of algae. In the summertime, Lake Erie can turn green because of the algae growth. In 2014, an unusually severe algae bloom required the city of Toledo to completely turn off its water supply to its residents for 3 whole days. Remember, this is a highly developed area of the world where residents assume that their government will be able to keep the water running. A large city like Toledo turning off its water for 3 days is virtually unheard of in the US. The people of Toledo were outraged, and so they banded together, and with help from the environmental nonprofit that we call CELDF, they wrote a law called the Lake Erie Bill of Rights, or LEBOR. That law said that Lake Erie and its watershed had the right to exist, flourish, and naturally evolve, and that the people of Toledo had the right to a clean and healthy environment, including a clean and healthy Lake Erie. LEBOR, the law, I'm going to call this law LEBOR because that's what everyone here calls it. LEBOR also included penalties for the violation of these rights. LEBOR's proponents immediately encountered significant legal difficulties. The city council, the governing body of Toledo, didn't want to adopt LEBOR into law because the council was advised that it would be sued, the law would be invalidated by a court, and the city would be responsible for the attorney's fees of the people who filed the suit. That was, by the way, good advice that Toledo got from its attorney. So despite the law's popularity, the proposed law's popularity, the city would not adopt the law itself. So the law's proponents, its sponsors, decided to put it on the ballot. In many US states, laws can be adopted either by local and state legislatures, or they can be adopted by popular vote of the people. But Libor's proponents couldn't get it on the ballot because there was a state agency that had to approve putting laws on the ballot, and that state agency thought Libor was probably illegal. Finally, the proposal gained so much popular support that the city council agreed to exercise its power to put Libor on the ballot. So the city council, which had first refused to support Libor because of pressure from the public, decided that it would at least put it on the ballot. Libor passed by the vote of the people, but the very day after it went into effect, an industrial farming corporation filed a lawsuit to invalidate it. That farming corporation, as you would guess, used phosphate fertilizer, and indeed its business depended upon the use of phosphates. The farming corporation claimed that the law was unconstitutional because the rights set forth in the law were so vague. Reading that law, the farming corporation said in its complaint, "We don't know if we can use any phosphate fertilizer, or if we can use it, we don't know how much we can use. This law doesn't tell us what we can and can't do." The court agreed that the law was unconstitutional because it was too vague to give notice of what conduct it prohibited, and the court, a federal court, invalidated Libor. This story, I told you this story at some length because it illustrates the problems with passing and effectuating rights of nature laws in the US. Vague laws are unenforceable here and unconstitutional here. Legislative bodies are reluctant to take the risk of adopting laws that they think will be invalidated because they will face costs, because they may face very costly legal fights. So, because legislative bodies are reluctant, most rights of nature laws in the US have been adopted through the initiative process by the voters rather than by legislative bodies. This is important because it shows that the people in the United States support the idea of rights of nature and are very willing to embrace it as a way of dealing with the environmental catastrophe. But it hasn't been just the courts that are the problem, and it wasn't just the courts in Ohio. The Ohio State Legislature, distressed by and frightened, I'll say, by the adoption of Libor, wrote into its state budget a prohibition against local adoption of rights of nature laws. I think it was the first legislature in the state legislature in the country to do that. Others have since then. Why would they do that? Why would they do that? Because at the state and federal level, the primary goal seems to be, of most legislators, seems to be to support the economies and to support the interests of their major donors, which includes, of course, the farming industry. Of course, I should clarify, the industrial farming industry, which is a much different thing than the small farmers of the country. And of course, big agriculture is not the only problem. The biggest problem is actually the oil and gas industry, right? But all of the large industries and corporate interests in the US are very effective at lobbying and advertising. And they protect their interests that way continuously, and that makes it hard to pass and effectuate rights of nature laws in the US. The Libor decision, because it invalidated a law that contained the usual rights of nature language, necessitated a course correction by the movement. We had to think about, okay, what are we going to do now? Because the existing rights of nature laws are all subject to the same kind of challenge, depending on how they're written and how rights of nature is used, but they may be subject to the same kind of challenge. The need for a course correction or adjustment became even clearer from what happened in Florida, where residents of Orange County sought to protect the health of their local waterways against the adverse impacts of land development. Proposed an rights of nature ballot initiative for that county. Not surprisingly, the state's governor and the state legislature perceived that proposed initiative protecting the rights of waterways as a threat to the state's economic health, because Florida's economy is driven by land development. And so, in a surprising to some move, the legislature adopted its own waterway protection law ahead of the vote on the county initiative. The law that the Florida state legislature adopted prohibited local rights of nature enactments. The county initiative was already on the ballot. The voters passed it by an overwhelming majority, but it was invalid on the day of its passage because of the state law. Nevertheless, the law's proponents, the local law's proponents, filed a suit to try to enforce it, and they publicized their lawsuit as the first brought in the US to enforce a local rights of nature law. Of course, the courts in Florida dismissed that lawsuit because it was clearly preempted, which is the word we use to say when a higher law invalidates a lower law. So the experience, the most recent experience with rights of nature law in the courts and in the context of state legislation, the most recent experiences have been very unfortunate, very bad for the rights of nature movement, one would think. I was worried that the combination of the Libor decision and the decision in Florida would kill the rights of nature movement in the US. The reverse has happened. It's stronger than ever. I think that's probably because people don't create and understand and plan their lives by reading the law. I mean, you don't get out of bed in the morning and read the law to figure out what you should do, right? You react to what's going on around you and what your needs and hopes are, and so forth. But whatever the reason, the rights of nature movement in the US is more popular than ever. So I've given you the bad news from recent years. Here's the good news. Proponents of the Orange County, Florida law, again, turned to the initiative process. They are trying to circumvent the problem of state law prohibiting local rights of nature laws by making an amendment to the Florida state constitution that will protect the right to a clean environment. This is the same kind of effort that has been undertaken in other states. New York adopted such a constitutional amendment last year. Here we call them green amendments to state constitutions. About 12 states have them. They are not what most people who spend their working time in the rights of nature movement would hope for, because these constitutional amendments establish a human right. But the thinking of the people who promote green amendments to state constitutions is that if nature is kept clean and healthy for humans, it will also be clean and healthy for other species. Time will tell if they're correct, but they are correct, and certainly correct in their thinking that humans are more likely to protect humans than they are to protect other species and Mother Earth as a whole. So the Green Amendments are a very hopeful development, as is the persistence of the people in Florida who were undaunted by their serious loss in the courts. In Colorado, several towns have opted to avoid the risk of litigation by adopting resolutions rather than laws that recognize the rights of nature. A resolution is, in the US legal system, is a legislative statement of policy or opinion. So if a city or a state wants to promote something like clean energy, or if it wants to oppose some proposal by someone else that they think is adverse to the state's interest, they adopt a resolution saying, here's what we believe and why. Resolutions are not enforceable in court. Thus, the adoption of a resolution would not trigger litigation or involve its expenses. So in the Colorado towns, which the Earth Law Center and I have been working with, mostly what small cities there have done is they've adopted resolutions that establish a governmental mechanism for recognizing and effectuating nature's rights. Usually, the governmental mechanisms is the creation of a sort of like a guardianship body that's part of the government, and its job is to promote, its ongoing responsibility is to promote the welfare, usually but not always, of a river, right? By advising the city council of adverse impacts upon the river that might result from, for instance, development projects that the city may be asked to approve, or by governmental practices or local farming practices. So these bodies are guardians, not in the sense that they have control the same way a financial guardian might, but they are the watchdogs that take care of these bodies of water. They also can do investigations, they can write reports, they can receive complaints from the public. A guardianship body could draft a law and hand it to its city's council and say, we think you should adopt this because. So that's a very encouraging development as well. Tribal nations are making great progress in the US. Earlier in our conversation, we talked about the central role that Indigenous peoples play in the movement. Fortunately, I have lived long enough to see tribes in the US attain more power, and their power and influence are increasing. It is such a relief to finally see that. So there's much to be hopeful about in the US. I have some final thoughts about things that we could do better in the US and maybe elsewhere. I think the US needs to be people working in the US need to be realistic about what the rights of nature movement is in the US. It's really a political movement, not a legal movement, at least not yet. But it can help change US laws to make them more ecocentric. The rights of nature movement in the US is, relating back to Caroline and Cedric's presentation, the best way, I think, for people in the US to understand that nature's our mother and we're part of it. We aren't its owners. Our law may make us our owners of pieces of it, but we really don't own it. We can't control it. And we have to understand that we are part of a family of life and we have to treat nature as our family. So I'll conclude now because I'm out of time and I'd rather talk with you than to you, but that's my report. So I'm optimistic about the future of rights of nature in the US, notwithstanding judicial and legislative setbacks.